Good afternoon and welcome to the final session of the CELS lunchtime seminar series of the term. Today we're going to hear about the realist trend of the Court of Justice of the European Union. There are complaints in adjudication that not enough is being taken into account. More relevant things should be considered when we strive to reach a decision. In economic law, there's a tendency to have more economics taken into account. And so there's a rise of a more economic approach. But it's not just economics that should be taken into account. There are other things. More recently, there's a tendency to think environmental sustainability should be taken into account in reaching a decision. So there are more and other considerations. Why and how these more things are considered is a topic of immediate concern. And to explain how this adjudication should occur, I am very pleased to be joined today by Damjan Kukovec. He is a graduate of the University of Ljubljana, and since that time, he has studied at Harvard, from where he obtained his doctorate. He has taught in Rio, Ljubljana, and elsewhere besides, and he is currently at the University of Middlesex, where he is the director of the PhD program. He has also practiced, not least, for the legal services of the European Commission. And I'm very pleased that he's able to join us today and share with us his wisdom and expertise. With that, Damjan, over to you.
Thank you so much. I am delighted to be here. Thank you for the kind introduction. Truly grateful, very kind of you. As you pointed out, I practiced law for a number of years. I was representing the Commission before the Court of Justice. And I'm also very much interested in the way the Court of Justice of the European Union thinks. So what are the trends? What do we make of the thinking of the Court of Justice? So before I actually discuss the realist trend that I will portray today, I would just like to, just really in a couple of sentences, explain really another article that I wrote. It was published this spring. It was on autonomy of EU law. And why is this even important? So the title of that article is The Court of Justice of the European Union for Hedgehogs. So I guess many of you know Dworkin's book, Justice for Hedgehogs. So he says, there's one unity in thinking about the law. And I was trying to figure out what that unity is. How does the court think coherently? What keeps its jurisprudence, on one track, and how can you actually explain all the jurisprudence of the Court of Justice of the European Union? And I'm arguing there that from perspective of a hedgehog, not of a fox. The fox is all sort of a, relative perspectives. The hedgehog has one big view, wisdom. So from the hedgehog's perspective, the Court of Justice's jurisprudence can best be understood from the standpoint of autonomy of EU law. So I say, the fox knows many things, citing Isaiah Berlin quite clearly, but the hedgehog knows one big thing, and the fox, for its cunning, is defeated by the hedgehog's one defense. And this one big defense of the Court of Justice is autonomy. It's what keeps its jurisprudence coherent, and it is the way the Court of Justice aims to achieve all the goals and values of the European Union. But if you're interested in that's another article. Now, how does this relate to what I'm talking about today? So in order to reinforce autonomy, the Court of Justice's reasoning needs to be legitimate, needs to have coherence, needs to fulfill its basic task, which is, in Article 19, that basically interpretation and application of the treaties, the laws observed. And most importantly, it has to fulfill the requirements of Article 47 of the Charter of the European Union on effective judicial protection. So I just want to highlight in the beginning that it is, what I'm talking about today, I think is really important for the court's legitimacy, for its achievement of overall goals, and really to uphold the autonomy of EU law, which is, in my opinion, the court's central mission. So, I will speak mainly about competition law cases, state aid law cases, and trademark law cases, simply because I've been studying now in depth for quite some time, and I also teach international competition law. However, as you will see at the end, what I will say, and basically the implications of the realist trend that I'm explaining are important and relevant for every field of EU law. It is just that I really targeted these three areas of EU law. And okay, as I said in the beginning, particularly in competition law, there's a big debate. Is there enough economic thinking of the Commission, the courts, too much perhaps? Are there any alternatives, and so on? So I'll touch on that as well, because what I'm portraying in actually an article that's been published by the EUI recently is that there's a realist trend of the Court of Justice, and I'll explain that in a minute. And this realist trend and this thinking can be decoupled from economic thinking. So they might overlap, they might totally overlap, but not necessarily. Okay, so that will come, that will become clearer probably in a couple of minutes. So, right, so the Oliver Wendell Holmes, the big starter of American legal realism, Justice of the Supreme Court, I think wrote in 1895, The Life of Law's Experience. So in order to understand the law, in order for a judge to adjudicate properly, a judge needs to get involved with the facts of the case. And I think this is really visible in what the Court of Justice has been doing. I would say, in the past decades, of course, legal realism has been with us for a century now. But I think that what the Court of Justice is doing, has been doing recently, really shows a pronounced trend to legal realism. So let me just tell you how I'll structure my lecture, so that it will be possibly easier to follow. So at the beginning, I'll explain shortly the jurisprudential roots and significance of this realist trend that I'll be describing, as I said, through competition law, state aid law, and trademark law. And then I will put on the table three propositions of the court's turn to realism. So I will explain how the court turns to realism through three propositions, which I've sort of put together based on realist thinking and based on what I can see in the judgments of the Court of Justice. Number one, understanding law in its social and economic context. Number two, avoiding premature termination of engagement with the relevant facts and interests. Number three, a robust articulation of socially undesirable harm. So these are the three propositions. And then I will speak about the trend itself, that it's not a completely linear trend. Of course, it is not, as no trend is. And the need to calibrate these propositions in every particular case. So, so in this piece, I was more possibly thinking like a judge or, someone working at the court than an academic, or probably, I think I have my two hats on in this piece, and as you will see in this lecture. But really, you know, how the part of the lack of linearity and calibration of 3 propositions will show how judges have to deal with the cases. And I really think it sort of explains what the Court of Justice and the General Court, particularly Court of Justice, have been doing relatively recently. And at the end, I will highlight the connection between this realist trend that I'm explaining and the effective judicial protection. And as you will see, as I said, you know, the court has, I don't think that, you know, what the court is doing, that this is totally haphazard. And I think I would say it's a thought out plan in the background, how to achieve really effective judicial protection in the European Union. And I'm trying to identify, to articulate this trend. I would say it's better to call it a trend than, you know, any particular plan. You know, how does the court do that in several fields of law? And right. So number 1, so I will start with the jurisprudential roots and significance of the realist trend. So as I said, Justice Holmes said, law is not a mystery. It's not a deduction from principles of ethics or admitted axioms. Instead, law is what courts do in fact, right? Life of law is experience. And then Felix Cohen, Ronald Coase, Lon Fuller, and several others were following his suit. And Felix Cohen said that obviously legal thought needs to have roots in reality. We have to be conscious of that. And you know, sometimes academics are less conscious of that. Judges obviously have to pay attention to this fact particularly. And it is important, as Lon Fuller said, that concepts are not a container of a thing, but an activity of a conceiving mind. So I think what is really important in realist legal thought is the fluidity of the meaning of concept. You know, they're not a container of a thing, but you really need to have a look how those operate in reality, case by case, and judges and academics obviously need to draw the right conclusions from them. So, Felix Cohen also said that legal concepts are not supernatural legal entities, a pre-existing something, embodying a fixed common morality, but are rather judicial constructions. Okay, so it's not that law has necessarily an inbuilt morality that we just need to apply. That would actually make our work much easier. It is much more complex than that. Concepts are really judicial constructions that we all need to engage in from different perspectives, but thoroughly, and not terminate our analysis prematurely or draw conclusions from the seemingly inherent meaning of concepts. So, and you know, finally, I would just like to point out Hofeld and Coase, who argue that a clear identification of harmful conduct is critical for clear legal analysis. So, as you will see in the 3 propositions I'm putting on the table, the first 2 are more factual, and the third one is normative. And law needs to be built on social ideas, right? We have to construct. The court needs to construct judgments built on social ideals, and we need clear normative guidance. So we should not make errors of law by you know, coming to conclusions just based on facts. The normative part is really, really important, as later the realists also argued. So, and we have to clearly identify harmful conduct. What do we deem harmful in society today and what we don't? So we have to embark on a, you know, careful analysis of normative premises we work on. Okay, so you know, I just set out some hallmarks of realism, which have become, you know, really the hallmarks of global legal thought, right? I mean, realism spread around the world, particularly after the Second World War, when American legal thought was becoming very predominant worldwide. particularly in the Western world. But I will not go into much more detail about the background of realism, or the point is not to portray really all the jurisprudential developments, not at all. The point is really to it's a reference point. So what the realists have been saying is a reference point for trying to figure out what the Court of Justice is actually now doing. So, and I will just repeat the three propositions now, so that you may have forgotten them a little bit. So again, first, understanding law in social and economic context. Second, avoiding premature termination of engagement with relevant facts and interests. So you see, these are really the factual ones. And third, a robust articulation of socially undesirable harm. So, so let me then turn to the first one. Oh, and maybe just one more thing that I'd like to mention. What is important here is that we distinguish the realist trend from the economic trend, as I said before. So if we argue that we have this realist trend and we should continue with it, my argument here is this is a very good trend. It is very important for the quality of judicial decision making, but it does not necessarily entail economic thinking. Okay, so and this is particularly important that we distinguish between them because these insights that I will explain, which are important for Article 47, are actually to fulfill the requirements of Article 47. Effective judicial protection can be actually used in any field of European Union law. All right, so understanding law in its social economic context, that's the first proposition I'm putting on the table. So basically, as I said, human inquiry does not occur in a vacuum. It's a situated form of activity. And lawyers, academics and judges have to look at the social and economic context of what we're actually working on, right? And this move towards an enhanced inquiry of the social and economic context of the Court of Justice is particularly seen in the by the interpretation of the by object violation of Article 1.1 of the treaty. All right. So as you know, according to long-standing case law, by object restriction of competition is so likely to have negative effects on competition that it would be redundant to prove its actual effects. Okay, so for a long time, the court was criticized that it is moving too quickly towards the by object analysis, that it doesn't look into the actual consequences of the activity on the market, and that it concludes that there is a violation of Article 101, simply because it seems that the gravity of the violation, sort of the moral dimension, is so negative that in itself a particular activity should be deemed to be prohibited. So this has been a long-standing critique of the Court of Justice. And then in the Carte Bancaire case, I think it was in 2014, the Court of Justice decided, very importantly, that so basically that when looking into the by object analysis, the court really has to dig deeper. So not just conclude and terminate the analysis quickly, but really look into the background, into the context, into the objectives of the agreement that the court is looking into, and so basically the wording of the agreement, the objectives, and the economic and legal context. So what happened there? Basically, there was a group of banks, the Carte Bancaire group, which charged different fees for banks which were really active in getting customers. And those banks who were actually not so active in getting customers were charged much higher fees. And those who had to pay more complained. This is a violation of Article 101 of the treaty. And the court concluded, the general court actually said, yes, this is the by object violation, in a sense, even unequal treatment. And they said this was basically a restriction of Article 101. Now, the Court of Justice noted that there's more to this case than just a mere restriction. The Court of Justice noted that actually we are talking about two markets. We're talking about the markets of getting the banks to join the association of banks, and then we have another market, and that is really getting the customers on board. So there was a two-sided market, and the general court somehow too quickly concluded that there was a restriction on one side, on one market, and there was some restriction for sure. But however, that restriction could totally be offset by bigger competition on the other market. So the Court of Justice said, you general court did not look into the legal and economic context. You really have to diligently check everything and really inquire about very diligently how the markets function, what the background reality is. Not to dwell on this point too much, but the similar development can be seen in many other cases. Allianz Hungaria, Maxima Latvia, generics case, very interesting preliminary reference case that came from the United Kingdom, Budapest Bank, and so on. So the point really is look into the legal and economic context before you draw conclusions. Okay. And so we need a really robust analysis of the background facts. So why is this important? Let me portray that with a trademark case. Okay, so there's a recent trademark case that is called, I will just maybe use the acronyms FU Goethe. All right, so it's a profanity in English that I just may not spell out right now. So FU Goethe. All right, what happened there? What happened in that case? Just to draw a comparison with with all these interesting 101 competition law cases. A German company released a comedy entitled F you Goethe. I'll just say it, fuck you Goethe, all right, to wake up the participants. There was a big success. This film was a huge success in Germany. Two more sequels were then later on produced. This company actually wanted to register the trademark fuck you Goethe. Now, the European Union Intellectual Property Office in Alicante denied the registration based on violation of the principles of morality. This is an absolute ground for refusal based on the trademark regulation. And the general court agreed. So they all said, this is immoral. There's inherent immorality to it. Somehow like the by object violation. There's an inherent restriction. No, we have to forbid that. Okay. Now the Court of Justice on appeal, and it did admit the appeal, which the Court of Justice rarely does in trademark law cases. It concluded that there was no violation of morality, basically, that there was no proof that anyone's feelings were hurt in the way that both the office in Alicante and the general court argued. Both Advocate General Bobek and the court said, you did not look at the background facts, you did not engage properly with the reality on the ground. They looked into the German market because the German market was relevant in that case, and they realized that this was really a huge success. This film was a huge success. There was absolutely no proof whatsoever that anyone in Germany was ever offended by its title. I'm sure you all know Goethe is a very famous German writer. However, even the Goethe Institute, which is the institute that promotes the German language and German literature and so on, used this film in its promotions and in its activities. So, it was really what the Court of Justice thought. The General Court and the office were just not looking into the facts on the ground. And in fact, the Court of Justice didn't say it, but it is, I think it's the perception of my perception, and probably also of other commentators, that judges were enforcing sort of their own sense of morality, rather than looking into the meaning of what is behind it. So, in the word of Felix Cohen, they were enforcing a pre-existing moral something that I was talking about earlier. So you see, this first proposition, look into the context, is very important. And it also prevents arbitrariness. So the judges do not just enforce their gut feelings. I'm shocked by this profanity, which probably sounds more shocking to someone in Cambridge than someone in Germany. But the point really is that that the court looks into the background, and that it avoids arbitrariness, so that judges do not merely see a case, say, well, this is morally repugnant one way or another in competition law, trademark law, elsewhere, and come to a conclusion. No, they have to sort of step out of their own moral realm even, and see what's going on the ground. So this is proposition number one. Proposition number two, all the facts and interests at stake have to be taken into account. It is somehow linked to the first proposition, but it is important to separate it from the first proposition, because this is not just mere fact gathering, but it's an analysis that has profound implications for the quality of judicial review, as I'll explain in about 5-10 minutes. Right, so here, it is similar cases come into play. Carte bancaire, generics, Budapest Bank, and what happens there is that if there's a strong indication of pro-competitive effects, or at least that there's ambivalent evidence in terms of what are the actual effects, what is the law in action, an in-depth examination of the effects of particular agreement must be carried out. So this is quite clear in those cases that I just mentioned. And also, I'm sure many of you know the Intel case on the exclusivity rebates, which was a case on Article 102 of the treaty, views of dominant position. So the General Court rely on the Hoffmann-LaRoche judgment on the presumption that granting those exclusivity rebates is by its very nature capable of foreclosing competition in violation of Article 102. So the General Court did not think it necessary to address Intel's criticism of the Commission's extensive economic analysis of Intel's rebates, and the Commission actually was using the as efficient competitor AEC test, but the General Court just said, this is such a grave violation. We conclude that there was a violation. So the General Court was really moving really too fast. It was prematurely terminating the analysis. Now, the Court of Justice, on the other hand, opened the possibility of the undertaking to rebut this presumption. So the Court of Justice, unlike the Advocate General Vow, they did use Hoffmann-LaRoche, but they said, well, there's a strong indication of pro-competitive effects, and they have to be taken into consideration. And the Court of Justice actually annulled the judgment of the General Court. And I think, if I'm not mistaken, the General Court's judgment after the referrals coming out in January, February. So look out for that one. So this is really important. I mean, this happened in the Budapest Bank as well. That the defendants came up with pro-competitive effects argument, and the court said, well, we have to look into that in detail, much as much as it seems that there is some sort of by object violation in Article 101 as in Article 102. Now, what is important is to say is that basically taking all the relevant facts into consideration is basically the basic principle of good administration, which is required not just by Article 47, but by Article 41 of the Charter. So the European Commission has to be really diligent in its investigations. And if you look at the relevant, at the recent case law, you will find numerous cases in which the courts of justice, but then lately also the general court, so it's a common trend, have been really paying attention to what the Commission is doing in state aid cases, merger cases. So let's say in state aid case, there's a recent case of Kerkosand, in which the Commission did not look correctly into the block exemption regulation concerning just the question of is a company an SME or not. So it did not diligently check what the national authorities were doing. In a merger case, Deutsche Lufthansa versus the Commission, the court did not take, the Commission actually did not take into account several important facts raised by the main party. I won't go into those facts, just to let you know about this case. Group Canal Plus, that in which the court said the Commission has to take all the relevant interests at stake into account, including those of the third parties. There's the recent Tempest case in which the Court of Justice actually limited the all the requirements imposed by the general courts on the Commission, and that case itself is sort of echoing an earlier case in state aid law, Florence Košice, in which I think many commentators agreed the court went too far in the burden that was put on the Commission to prove what a private investor would do in a similar circumstance. So there's just so many cases in which the Court of Justice and general courts are really putting pressure on the Commission to really investigate carefully, to take all the relevant facts and circumstances into consideration. And what is important to know that this has its rationale, as I said before. And just by the way, if any one of you is looking into restrictive measures, the trend is very similar there. Obviously, the diligence there is, it's the council's diligence that the courts are looking into, but it's really the trend on institutions to safeguard the procedures, the individual rights, and the performance of the institutions in light of Article 41 of the Charter. So, but there's a really important rationale here. If the court is not researching the facts quite clearly, the court is bound by the facts that are let's say presented to it by the Commission and other parties. So if the Commission doesn't do its job properly, it is difficult for the courts to draw the right conclusions from those facts, because simply they're not presented to it. So that is why this really fits into the trend that I'm describing. I have to probably move on to the third point. Really, it is asking the Commission, other institutions, the office in Alicante, to look beyond what is just out there. Do not stop too quickly. This is also visible in several trademark cases. You can have a look into those in my paper. So I mentioned the Simba Toys case, the halloumi, barbecue halloumi case. So the court is really saying, look into all aspects of the case. Otherwise, we just cannot perform a good analysis, and Article 47 is at stake here, right? And this is very important for the rule of law, for protection of individual rights, and for the whole decision-making process. Now, let me move on quickly to the third proposition I'm putting on the table, and that is a robust articulation of socially undesirable harm. So I think I would anchor this in Wesley Hofeld's insistence on distinction between a right and a privilege to harm. So basically, Hofeld argued himself that when harm is inflicted on a competitor, the court does not automatically award a plaintiff a remedy unless justice and policy, the normative aspect of the case, so the values of the legal system so require. In other words, some competition on the market is always there, right? I mean, I've been arguing in one of my now older papers, Hierarchies as Law, that harm is actually a central element of law, and that we cannot wish it away. There's always harm on the market, or even harm, in our daily lives. So, so basically, and not every harm is prohibited, right? So the commission was, particularly commission, but also the court was critiqued, but like this is old critiques about 20 years ago, that it is drawing conclusions in competition law cases, particularly on the basis of some harm on the market, and then prohibits this activity, which quite clearly leads to the over-inclusion of over-inclusion, meaning that too much is prohibited on the market, and that the market cannot function because there's not enough competition. The pro-competitive activity is actually being prohibited, but also under-inclusion is possible. So what I'm also arguing, by the way, is that if these three propositions are not taken into account, the whole analysis is much less targeted. And I think this is also, there's a thin line of between the arguments of the parties, and the court needs to decide who will win, who will lose. And if the court is not looking to the facts, not looking into the economic background, socio-economic background, if the institutions are not doing the job properly, and thirdly, where I am now, if the socially undesirable harm is not articulated properly, the analysis simply is not targeted. It can be over-inclusive, under-inclusive, and that is quite detrimental to the rule of law and to effective judicial protection in Article 47. So I'm saying, there's often even a razor-thin line between anti-competitive and pro-competitive conduct, and what the court is really doing is trying to target the analysis through the three propositions that I reconstructed. So you will see, we don't have the time to go into the details of the case, of many cases. So, there's Intel that I mentioned already, but there's also Post-Denmark 1, Deutsche Telekom, Telia Sonera, in which the court very clearly said, yes, there's harm on the market, but we need to have a robustly articulated theory of harm. It cannot be, we cannot derive conclusions just from some harm on the market. The commission has to be careful in articulating the harm. We have to have also the consequences visible of anti-competitive conduct. And this is quite fundamental, and I think a qualitative leap of the court. Now, at this stage, I might actually say that I might actually portray, just with one example, the difference between economic analysis and the realist analysis. So the realist analysis would really say we need an articulated theory of harm. So what goes against the values of our system? What is anti-competitive? So we have to have a clear picture of what we're actually doing. Now, economic analysis would say we use economic analysis for that. So, the as efficient competitor has been very prominent in Intel, Neo, and other cases. And these cases actually show the realist trend that I'm portraying, but they also show an enforced economic analysis, the enforced usage of economic analysis by the Court of Justice. Now, there's a case, Post-Denmark 2, that you might, the audience might look into. There, the court actually did not use the as efficient competitor as a theory of harm. Also, the Advocate General Kukovec did not suggest it, simply because it was, I think, quite rightly thought that the Danish Post had a 70% share market share. No one could possibly be as efficient as they were. Very high barriers to entry, very specific market. High economies of scale, strong network effect. It were just impossible to be as efficient as the Danish post was. So the court diverted, and they said we're not using this test. And this, I think, is completely in line with the trend that I'm describing, because we have to be aware that economic analysis, much as it is very important and very useful for competition law, no doubt about that, these tools are not perfect, and we have to deal with the imperfection of these tools. And obviously, the Court of Justice has to take all the circumstances into account. So I'll just probably move on to so this is the third trend. Third proposition that I'm putting on the table, and it's also visible, in trademark law, where the court said, not every loss of customers is a concern to a trademark proprietor. It has to be something else. It has to be something more than that, and it has to be articulated what it is. And you might want to have a look at Google France, Interflora cases. L'Oreal versus Belure actually is another case, a little bit earlier case that sort of disintegrated the property right into different parties' interests. Another, obviously, realist move that the court made, so that the consequences of some activity, the negative consequences of activity on the market, on the trademark right, can be more accurately analyzed. So, property right, obviously, it's the ultimate legal concept. And I think in order to perform the analysis that I'm describing in the paper, the Court of Justice had to break down the trademark right into all these interests. And it did so successfully. And, for this reason, I think the analysis in trademark is also much more targeted, and the harm can be articulated much more clearly. All right, so just a couple of words, and then I'll give me a couple of more minutes, and then I'll come to a conclusion. I'm happy to discuss more during the Q&A session. So obviously, as I said, as no trend ever is linear, this one is not linear either. What I'm saying is, I'm giving 4 examples where one could argue, well, there is no such trend that you're describing. But I'm actually saying that these examples, and possibly others as well, actually confirm the trends. They don't refute it, and they actually show that the Court of Justice, when deciding cases, has to have all the considerations in mind, right? So the systemic considerations of the system, the overall coherence, and so on. So what might at first sight look as a departure from the trend, actually, if you look at it closely, it reinforces it. So, Constant Grundig is obviously a note case, but in that case, as everyone knows, the Court of Justice did not look into the actual effects of, in concreto, of the activity of the market. They just said, this agreement is partitioning the markets in the European Union, so we'll prohibit it. And this was somehow restated in the GlaxoSmithKline, a little bit newer case recently on parallel trading, where the court did not look into pro and anti-competitive effects of the agreements, but rather said partitioning of the market is just something we, of the common market is just something we don't allow. So, this is a systemic concern, which I think perfectly fits into the overall picture. Then there's Football Club Barcelona, recent state aid case, in which the general court said, well, we have to have a look at all the pros and cons of the scheme. It was a state aid scheme into consideration. But then the Court of Justice said, well, that's right, generally yes, but you have to take them into account at the right moment in time. So for procedural reasons, the Court of Justice said, you did not take them into account at the right moment. You should take them into account only when you recuperate, when the Commission recuperates aid. and actually it struck down the general court's judgment. So, and the reason really was, administrability and the procedural demands of the European Commission when investigating and when investigating the state aid law cases. All right, so let me just finish, because I think we're running out of time. There's more cases that I mentioned: CK Telecoms, Even Tech, where on the first side, on first sight, one could say, this is not the trend, but I really think it all fits together into this court's conscious engagement with the propositions that I'm putting on the table, in order to have a clearer, more targeted, coherent analysis. Now, just to finish off, why is everything I'm saying really important for effective judicial protection? So, Article 47. Basically, as you know, particularly in 101 cases, 102 cases, which are of a criminal nature, the court really has to perform an in-depth judicial review. There's a margin of appreciation. However, the Court of Justice has said, both in 101, 102 merger cases, state aid cases, that margin of appreciation is there, true. However, that does not prevent the court to actually check all the particularly, so for economic issues, the margin of appreciation is there, not for legal analysis. However, that does not prevent the court to really check all the details of the case according to the Tetra Laval formula. So, I mean, if you look at cases such as Amazon, in the stated case Amazon, or Apple, or CK Telecoms, you will see that the general court was really going into depth and wasn't leaving much of the margin of appreciation to the commission. However, in order for the court, as I said earlier, to really perform the judicial review that it's required to perform, these propositions have to be taken into account. Obviously, the institutions have to do their job. The parties have to be heard, in a sense, not just in the sense of right to be heard, but when a party raises a defense, it is very important for Article 47, for the adversarial procedure, that the channels of communications are not somehow interrupted, so that if the termination of analysis is just premature, the parties' objections are not taken seriously, and as a result, cognitive failure occurs, as it did also in FU Goethe, for example, or Intel or Carte Bancaire, in which, in all those cases, the analysis just finished, and the arguments that were put on the table were not, seriously taken into account. It is important. This is also important for equality of arms, quite clearly. And this is really important from the perspective of the legal procedure. Quite clearly, when what makes the adversarial procedure impartial is the really very dialectical relationship and interchange of information, and the relationship between the thesis and antithesis. And if these are, if the propositions that I'm discussing are not taken into consideration, the adversarial procedure somehow stops working and becomes fuzzy, unclear. On the other hand, when the analysis is robust, when everyone can, put the evidence on the table, put the, argue the plausible efficiencies, when the theory of harm is clearly articulated, it's not just that the court is deriving normative conclusions from the facts, then we're actually, really can speak about effective judicial protection in light of Article 47 of the Charter. And going back to autonomy, where I started, I think this is very important, what the Court of Justice has been doing, in particular in the last decade. It is very important to protect the autonomy of EU law and its legitimacy. So thank you very much. I hope I did not speak for too long.